Okay, so let me tell you a little bit about GRU. We're a little bit over 100 years old now. We have 5 different utilities: electric, natural gas, water, wastewater, and fiber optics. Presents a lot of different issues for my utility. Some of the, what I would call, sexier things about GRU are our renewable energy. So we've got 20 megawatts from a solar feed-in tariff and 100 megawatts under a biomass PPA. The gentleman a couple rows back, Ed Regan, is to thank for a lot of that GRU has. He was instrumental in getting us most of our renewable power, which is a very cool thing to most of us in this room. However, there are some folks in the Gainesville area who don't love our rates right now, don't appreciate the renewable energy, and that causes a lot of public records requests. Okay, so let's talk a little bit about GRU's program. Since I took this job about 3 years ago, on an average, we've had about 1,400 to 1,500 public records requests a year. So I have my normal job to do, handling disclosures for the utility and all the contracts and real estate documents, and then trying to manage this as well. That kind of leads into the last bullet, which is we created a public records department now. And so I no longer filter all of the public records requests. It goes through another gentleman at my utility who kind of works through the different requests, channels them out like the wedding coordinator to the different departments, takes all the information back, and then if he has legal concerns, he comes to me. So I'm still copied on all of the public records requests. I'm still seeing what's going on in the utility, but I'm no longer the wedding coordinator. I'm no longer responsible for, going after people and making sure they give me their records. I just didn't have the time to do it. So we've been sued over our program. I was lucky enough to testify at court over our program, and we were validated by the court. The plaintiff did not win, which provided a lot of pride to us about our public records program and that we were, in fact, administering the law correctly. All right, let's talk about the basics about what makes a public record. This is a quote from Pam Bondi, our Florida Attorney General, and I think it really sends the message of the importance of the constitutional right to public records in the state of Florida. And I try to tell my executive management team as often as I can, it's like, listen, we're not doing anything scandalous here. We're running the city's utility. We're doing business. If we have to provide a record, we provide the record. People get so uncomfortable, I think, with the idea of providing emails or providing your spreadsheets or showing your coal contracts. You just have to, once you come on board GRU and you're going to work for us, you just have to get used to our business is open. It has to be open, and this is a perfect reason why. Your Florida Attorney General's quote really cements that. So what is a public record? A record received in the course of business, in the official course of business. That can be a voice message, that can be a text message, it can be a standard, Word document that you make on your computer. It can also be handwritten notes. And so this is one of those issues that I oftentimes have to talk to with my executive team. They go to a meeting, they take notes on whatever's going on in the meeting, and then all of a sudden we get a public records request for something that captures that subject, and they come to me panicked about whether they have to produce their notes or not. And so it's sort of a lawyer's answer, it depends. If I go to a meeting and I take notes about what's going on in the meeting, and I only use that for my own recollection or my own memory, that is not a public record. It becomes a public record when I then use that note to somehow perpetuate knowledge. So if I've gone to that meeting, I take notes, and I put it in my own file and I don't get it out again, personal notes of Shayla. If I take notes in a meeting and then I go to my CEO's office and I say, all right, let me tell you about A, B, and C from this meeting, I've now used that to perpetuate knowledge. I have my own little record keeping schedule about, I mark my notes so that I know if I've used it to perpetuate knowledge or if it's still my personal notes. I don't expect everybody to be that detailed, but I do think it's a good habit to sort of mark your notes as to whether you've ever used it to inform someone else of information or not. And hopefully you don't have these issues because you just don't have this many public records requests. So perpetuate, communicate, or formalize knowledge. Those are the important words there. Let's talk about some examples. These are the types of things we get at GRU. One of the more interesting things that people like is emails between the in-house counsel and the CEO. So several months in a row, When I first took the job, I was getting all these requests about any emails that I had exchanged with my CEO and any emails he had sent to me. We're not getting those as much anymore, but in the first probably year of my job, we were getting those monthly, and so then every email that he and I had exchanged then, was given to the public, and those are now posted on a website. So if you Google my name, you get all kinds of emails that I sent over the year. Every month they would post them to a website. It feels really like your privacy is violated at first, and then you sort of get used to it. And the great part about being a lawyer is I don't put any legal advice in writing. It's like it saved my job, so I have a lot less to do. But the financial models and projected rate increases, that generally makes my finance department very concerned. They don't like to give any of their model information until it's pretty cemented. As you know, rates change during a budget cycle. Your rates can start at one place and end up differently. And so they're generally very uncomfortable with giving any of that information ahead of time. But as you know, it's a public record, and so it sometimes has to be given. Okay, this is a really great example of a public records request. It's for coal contracts in 2012 and 2013. We have some very savvy public records requesters in Gainesville, and so he was trying to get at different fuel rates, and he was trying to back into some of our fuel numbers by this example. This is a lawyer who made this request. This is another lawyer who made this request. Now this is very savvy. What he did in this situation, he was making requests of my emails, and my emails weren't producing the type of information he was hoping to get. So he very craftily thought about, I'll request Shayla's outside counsel bills, and he did just that. So he took the June 2013 counsel bill with my bond counsel firm, Orrick, Harrington, and Sutcliffe in New York, and he went line item by line item, and then he made the request to me for me to produce everything that was in that public records request. It's really, really savvy. Now, as you can tell, I don't know how much you can read, but lots of this stuff I wouldn't have. My outside counsel is corresponding with other attorneys in their firm, and they wouldn't produce all of this for me. I don't have any reason to have all of this. And so it was very costly to go to my counsel, bill at their hourly rate to then produce these records. But we did just that. But this is the way they kind of get into knowing what I'm working on. There's been times where we're working on all kinds of different really creative, different ideas at GRU, and at first I had wondered how they were getting to this information, and then I realized they're just going through all the bills. We now post a lot of these bills on our website. That's a lesson learned for us at GRU. This was such a voluminous process and just so taxing on everyone at the utility that what we ended up doing is just posting most things online. It sort of eliminates the sexiness of it. It's all available online. We can just point you right to the website where you can go and get whatever record you want. And that's a management decision. You're going to have management who's generally uncomfortable doing stuff like that, and then you might have more agreeable management to doing something like that. So I would really caution you, if you've got supportive management to do that, put as much as you can on the website. If you get 3, 4, 5 requests for the same documents, you might as well preserve your time. That's exactly right. So I had to contact in fact, I sent this public records request to my outside counsel. I said, please review it and give me an estimate of how much you think it would take you to get all of these records together. He provided me, an estimate of his hourly rate and how many hours he thought it would be. I then provided that to the requesting customer and let them make the decision. And I do believe they ended up narrowing the request. They didn't end up want everything, because I think the estimate was like $12,000. And so they did narrow their request so that they could afford it, but they did end up getting a lot of these records. And that's another point that I think is important to have with your outside counsel or your outside consultants. And I was having this conversation with Mr. Ed Regan earlier today, so I think it is an emerging issue. So something we at the utility, we get comfortable with this. We don't like it, maybe. It makes us upset sometimes, but we generally are comfortable with the idea that all of our records are in fact public. But our outside counsel and our consultants, they're not used to this. This is weird to them. Attorneys are generally comfortable with attorney-client work product. They're not used to producing any records like this. And engineering consultants aren't used to this either. And so I generally try, when we hire new firms, I try to have this conversation with them and say, listen, you're going to be producing some stuff that I know a lot of folks in my city are going to want. You need to get comfortable with this up front. If you're not comfortable, don't bid, because you're not going to like how much you have to produce. It's very uncomfortable. And so I think sometimes when you alert them to the issue early, they kind of They don't like it, but they get used to it or they get comfortable with the idea. So what Mr. Regan and I were talking about earlier is if two attorneys at a firm, at a private law firm in New York, are talking about me, GRU the client, and they're emailing back and forth and they're sending each other documents and billing GRU, those are then public records, unless they're otherwise mental impressions for litigation. So let's just assume they have nothing to do with litigation. In that event, those are all public records. So, that's a very uncomfortable thing for private law firms to have to produce. And they don't think about when they email me, they remember, oh yes, be careful emailing Shayla because this becomes a public record. But when they're emailing lawyers in their own firm, they sort of lose track of that and lose sight of it. And producing those records makes them very uncomfortable. But they'll do it for a price. Okay, so that was a great question, by the way. Emerging issues. So it's a little pop quiz just to get you thinking. So your utilities, media, and communications department provided Facebook posts and Twitter feeds about storm outage impacts to your utility. Would these be public records? And they actually are public records if they're made in connection with official business. This was one of those things at GRU that we really had to work through because the communications department wasn't accustomed to saving everything that they were Facebooking with folks. So, we might have a storm outage and then 70 people respond under the storm outage about my power's still out, you still haven't cured my issue, and so then my GRU staff was responding to these different customers. We save all of this. They turn this at the end of a day into a Word document, and then we just store it every day as a Facebook Word document from that day. And so that's how we're now storing these types of Twitter and Facebook feeds. Okay, so this is similar. Your utility sent out a text message to thousands of customers about additional rebates, last-minute rebates that are now available. Would this text message be a public record? And the answer is yes, if it was sent in the official course of business. This is a very superficial example, and it's pretty basic, and I'm sure everybody got it right. However, text messaging is really an emerging issue, and it's generally something where I think when you have 140 characters on your phone, it just seems really basic, and it doesn't seem like official business. But it in fact often is. I mean, oftentimes I'll get direction from my CEO through a text message, or my CEO will ask me to do something through a text message, and that in fact is a public record. Can you pick me up a Starbucks? Where are you? Can you be here in 5 minutes? Those are not. Those are the types of text messages I just delete. What GRU has done, and my executive management team now does with text messages, is if a text message comes in that you yourself declare as to be a public record, you then forward it to your email account and then properly store it in accordance with whatever file it belongs in. And that's really pretty basic to do. I still have a BlackBerry, which is very dated, and that even has a way to forward to my email. So it's a pretty basic thing. This is the honor code. We're all working on integrity here with this system, and so there are certain people who are better about public records and the maintenance of public records than others. But I would encourage you to talk to your utility about getting a text message policy. I know some utilities or some folks have disabled the text messaging feature such that you can't get any incoming or send any. I think that's a bit extreme. Text messaging is a very convenient way to get business done, and efficiency is important in the utility, absolutely. So I think the important part is, at the end of the week, forward all of your text messages back to your account or come up with some type of your own little record-keeping tool that allows you to protect your text messages. I don't know if you've looked at your work cell phone bills recently, but if you get a work cell phone bill, it will show you everyone you sent a text to and every incoming text. So in the event you got a public records request and you didn't produce any, you look at a bill and it shows you sent 100 text messages in a month, but then you can't produce any of those records, it's going to look bad for your utility. So I have two phones. I have a personal cell phone and a work cell phone and a work iPad and we all have all of these different tools now. So if I get a text message on my personal email or my personal text on my personal phone, I just forward that to my work account. And it's just always my policy. I do it immediately so I don't forget, and I always do it the same way. So if I ever did have to testify, I could say, I've always done it this way. I've done it this way every single time. I know that because it's my policy. So it doesn't matter. I've had CEOs and I've had folks who will say, well, I got it on my personal email. Well, it's still a public record. It doesn't matter where it's stored. Okay, here's another little pop quiz. This is about your local news media requests unredacted monthly utility bills for your board of directors. Do you have to produce these? And the answer is most likely yes. The only reason you wouldn't have to produce your board of directors bills is if they were an otherwise guarded account. And so let's talk a little bit about guarded accounts. I have had board of directors who felt very certain that they should have a guarded account, which means their address should be redacted if a bill is ever given for them. So if somebody requested months of different bills, you wouldn't see the name or the address associated with the account. You would just see the usage. I'm going to flip to this next slide and I'll go back. So this is guarded accounts under the public records law, and these are the folks who do qualify as guarded accounts. So if your board of director was an otherwise guardian ad litem, he would of course be a protected guarded account, not because he's a board of director of your utility, but because he's a guardian ad litem. And so I have had situations where the board of directors, because they do make personnel hiring and firing decisions, they think they qualify under that human resource managers. They in fact don't, and let me tell you a little bit of the reason why. When your board meets and they make those types of board decisions, they're making a decision as a board. One commissioner is not making that decision independent of the others. If the vote is 4-3, that's the majority. That's the commission. That's the will of the commission, as opposed to one person being doing hiring or firing. I understand it's an uncomfortable concept. It's currently the status of the law, but I've had a lot of board of directors who did want their accounts kept private. And I think the reason is a lot of these articles, are about who's the energy pig or who conserves or who's better than others. And so I think that they can get turned into something that looks really bad. And if a commissioner has a pool and so his usage is higher than other commissioners, I think that's what they're trying to protect against. I get that it's very invasive. But this is the law. So that's the list. There's some others as well, but these were the more important ones. So just another example, if your board of director was an otherwise prosecutor in his day-to-day life, or she was a prosecutor in her day-to-day life, then she would qualify as a guarded account, but not because she's a board of director. Any questions about that? Okay. This is an email that we got from State Representative Perry's office. He had a customer realize that all of her bills were in fact public, that her delinquency information was public, and she was generally uncomfortable with that. I understand that. I feel that same way for her. I wish we had better protections, but her delinquency information and anything else is all public. Her home address, her home email, and I gave a talk like this similarly in Portland, Oregon, and my mom came with me. She's like my traveling sideshow. And when I gave that talk afterwards, we left the room, and she said, "Gosh, are my records all public?" She'd never thought about it before. And I said, "No, Mom, you have FPL, so it's an investor-owned utility, and your records are in fact private. However, if you take from a municipal, your records are in fact public." And so I think a lot of people don't realize this, and that's the example of this email to State Representative, to Perry's office. Representative Perry had been getting some emails from some different customers realizing that, oh my goodness, my records are in fact public. And that generally makes people uncomfortable when they realize that, and rightfully so. Okay, so these are just some of the things that are, these are the privacy issues that people do talk about. This last bullet, this energy usage, what GRU does is we do a large data dump every month, and it goes to this website. And what you can do is you can plug in your address, and then you can see in your neighborhood who's conserving, who's using a lot of energy. So obviously red is larger amount of utilities being used. The green are obviously the more conservative users. And so there's a mixed bag here. We have a lot of folks who really like this because you can see in your neighborhood, which is generally houses all built in the same year by the same builder, you can kind of see who's doing things better or differently or worse than others. And then maybe you can have a conversation with your neighbor about what is it you're doing better than I am to keep your bills this way, or et cetera. So like I said, it's a mixed bag. We've got some folks who really like it and some folks who don't. This is all public record information, and so there's really no issue with us doing this data dump every month. This procurement is an issue for me. I really care about the procurement aspect of public records. I don't know if you're aware, but you probably are if you read the clippings, but recently the biomass plant came online in Gainesville. And as a result of that, we get a lot of public records requests, and the company who built that biomass plant gets very uncomfortable with exchanging any information with us, and rightfully so. They get very hesitant to give us any records because they know we'll get a records request in due time and we'll have to make that public. And they want to protect a lot of their information. They're not a publicly traded company. A lot of their information is private so far, and so doing business with Gainesville has been, I would probably say, a headache for them. They're just really uncomfortable with giving all this information to the public. And so that's just one issue about how different companies are generally uncomfortable with giving too much information to us. So we might have an investment bank, or we might have somebody who's going to bring us a great idea. JP Morgan often brings us great ideas. And what we've done is we've done a non-disclosure agreement, and if JP Morgan or any other investment bank brings us an excellent idea that they consider to be trade secret information, or an idea that someone else doesn't have right now or hasn't brought to us, we do protect that. And we want to protect that. We want people to come to us with good ideas. And so everything that's happened with the biomass plant has put us in a really strange situation, because we want companies to come with us with cost-saving measures. We want investment banks to present different ideas to us. We love all of that kind of thing. Ingenuity is a really big thing at GRU, and so we want to continue to promote that. But at the same time, I understand that people are generally uncomfortable to give us their private ideas in the event that we have to provide something. So trade secrets can be protected, and the trade secret statute in Florida is not hard to meet. If you can generally show that it's something that gives you an advantage in the marketplace, you can meet the trade secret standard in Florida. So it's not a high threshold, which I try to give comfort back to these companies and say, listen, if you do believe it to be a trade secret, we can do a non-disclosure agreement and we can protect your trade secrets. They're still concerned, they still get nervous. So for me, this is an issue, and for my businessmen who are constantly trying to generate new ideas, they hate that these other companies don't want to give us a lot of information. So we'll have a lot of verbal conversations, but when it comes down to exchanging documents, they're generally uncomfortable.